Negotiable Instruments Act, Section 106, Reasonable Time of Giving Notice of Dishonour. Section 106 of the Negotiable Instruments Act, 1881 explains what constitutes a reasonable time for giving notice of dishonour of a negotiable instrument. The provision lays down separate rules depending upon whether the holder and the party receiving notice are situated in the same place or in different places. The section aims to ensure prompt communication of dishonour while also recognizing practical difficulties relating to distance and transmission of notices. 1. Purpose of the provision. When a negotiable instrument is dishonoured, notice of dishonour must generally be given to parties sought to be made liable, such as drawers and inducers. Section 106 prescribes practical standards for determining the time for such notice, ensuring commercial certainty, prompt communication, and preservation of rights against liable parties. 2. Meaning of notice of dishonour. Notice of dishonour is a communication informing a liable party that the instrument has been dishonoured by non-acceptance or non-payment, and that the recipient will be held liable on the instrument. 3. Different places. First rule. The section first deals with cases where the holder and the party to whom notice is to be given carry on business or reside in different places. In such situations, notice is deemed to have been given within a reasonable time if it is dispatched by the next post or on the day immediately following the dishonour. 4. Importance of prompt dispatch. The law emphasizes the dispatch of notice rather than its actual receipt within the prescribed period, provided the holder sends it within the required time. Once the notice is properly dispatched, the holder's duty is treated as fulfilled, and delays in transmission beyond his control do not ordinarily prejudice his rights. 5. Meaning of different places. Different places may include different cities, towns, or business locations, and the section recognizes that communication between such places naturally requires additional time. 6. Same place. Second rule. The section next deals with cases where the holder and the party receiving notice carry on business or reside in the same place. In such situations, notice is considered to have been given within a reasonable time if it is dispatched in time to reach the destination on the day following the dishonour. 7. Stricter standard in same place cases. Since parties in the same place can communicate more quickly, the law expects greater promptness, and a delay that may be reasonable between distant places may not be reasonable where communication facilities are readily available. 8. Commercial basis of the rule. The distinction between same place and different place cases is based on ordinary commercial practice, taking into account communication delays, business convenience, and practical realities of transmission to ensure fair and commercially workable standards. 9. Importance of timely notice. Timely notice of dishonour is important because it enables liable parties to arrange payment, recover from prior parties, and protect their commercial interests. It also helps preserve evidence and legal remedies, while failure to give notice within a reasonable time may discharge certain parties from liability. For more details, contact us.